Ready? Exercise number 22, legal matter, very important matter, start. Thus, there is an overwhelming line of cases holding Section 5 of the Limitation Act applicable to the matters in appeal and reference applications to the High Court under the Indian Income Tax Act, the Customs Act and the Bombay Sales Tax Act. Our conclusion in this regard is in line with these cases. Counsel for the respondents, excepting those in which revenue is the respondent, however, contend that the expression expressly excluded does not mean that the provision providing for appeal itself should say so, and that can be inferred from the scheme of the Act 1961 itself. Accordingly, it has been contended that the scheme of the Act 1961 clearly excludes application of Section 5 of the Act 1963, and therefore an appeal preferred under Section 260A of the Act 1961 cannot be admitted by extending the period of limitation. In our opinion, for express exclusion of Sections 4 to 24 of the Act 1963, the special law need not provide for its exclusion in the provision providing for appeal itself, and the express exclusion can be inferred from the scheme of the Act. We are further of the opinion that in a case where the special law does not exclude the provisions of Sections 4 to 24 of the Act 1963 by an express provision, it would nonetheless be open to the court to examine whether and to what extent the nature of those provisions or the nature of the subject matter and the scheme of the special law excludes their operation. One can come to the conclusion that when a special law does not provide for application of Section 5 of the Act 1963, it is expressly excluded. A reference in this connection can be made to a decision of the Supreme Court in the case of Hukum Dev Narayan Yadav versus Lalit Narayan Mishra under bracket 1974 bracket out 2 SCC 133, in which it has been held as follows. Quote, next para. Even assuming that where a period of limitation has not been fixed for election petition in the schedule to the Limitation Act, which is different from that fixed under Section 81 of the Act, Section 29 subsection 2 would be attracted, and what we have to determine is whether the provisions of this section are expressly excluded in the case of an election petition. It is contended before us that the words expressly excluded would mean that there must be an express reference made in the special or local law to the specific provisions of the Limitation Act, of which the operation is to be excluded. As usual, the meaning given in the dictionary has been relied upon, but what we have to see is whether the scheme of the special law, that is in this case the act, and the nature of the remedy provided therein are such that the legislature intended it to be a complete code by itself, which alone should govern the several matters provided by it. If on an examination of the relevant provisions it is clear that the provisions of the Limitation Act are necessarily excluded, then the benefits conferred therein cannot be called in aid to supplement the provisions of the Act. In our view, even in a case where the special law does not exclude the provisions of Sections 4 to 24 of the Limitation Act by an express reference, it would nonetheless be open to the court to examine whether and to what extent the nature of those provisions or the nature of the subject matter and scheme of the special law exclude their operation. The provisions of Section 3 of the Limitation Act that a suit instituted, appeal preferred and application made after the prescribed period shall be dismissed are provided for in Section 86 of the Act, which gives a peremptory command that the High Court shall dismiss an election petition which does not comply with the provisions of Sections 81, 82 or 117. It will be seen that Section 81 is not the only section mentioned in Section 86, and if the Limitation Act were to apply to an election petition under Section 81, it should equally apply to Section 82 and 117. Because under Section 86, the High Court cannot say that by any application of Section 5 of the Limitation Act, Section 81 is complied with, while no such benefit is available in dismissing an application for non-compliance with the provisions of Sections 82 and 117 of the Act. Or alternatively, if the provisions of the Limitation Act do not apply to Section 82 and Section 117 of the Act, it cannot be said that they apply to Section 81. Again, Section 6 of the Limitation Act, which provides for the extension of the period of limitation till after the disability in the case of a person who is either a minor or insane or an idiot, is inapplicable to an election petition. Similarly, Sections 7 to 24 are in terms inapplicable to the proceedings under the Act, particularly in respect of the filing of election petitions and their trial. Full stop. Thank you very much. Guys, there is one humble request. Please always try to repeat the matter, so then only your fluency and accuracy on steno will improve. And also, if you found the matter is excellent, you can give your valuable comment. And also, please subscribe my channel so that you can get next notification of matter. Thank you very much.